Ooh, thank you. Welcome, everybody, to today's book launch. Before we get started, I'd like to take a moment to do our land acknowledgement. We would like to recognize that First Nations peoples have lived on this part of Turtle Island for millennia, stewarding the land, the water, and all that contributes to life in this region. Today, the culture and presence of First Nations, Inuit, and Métis peoples enrich the lands and people of the territory. More than 2 centuries ago, the Mississauga people welcomed settlers to this territory, providing sustenance and engaging in trade and commerce. Between 1781 and 1820, 8 treaties were signed with the Mississaugas of the Credit First Nation, who opened their territory to settlement. Today, York University's Keele campus is located on Toronto Purchase Treaty Number 13 lands and is situated on the traditional territory of the Huron-Wendat and the Haudenosaunee. Treaty history is foundational, and it is our collective responsibility to honor the land as we honor and respect those who have gone before us, those who are here, and those who have yet to come. We're grateful for the opportunity to be learning, working, and thriving on this land, and we commit to learn the truth and be active in the process of reconciliation. And I just wanted to note that it's important for us, particularly as we talk about forced migration, that we acknowledge the history of forced displacement that has happened in this country and on these lands. And so to really do take a moment to think about the land on which you are joining us from and the history of the land that we work on now. It is with great pleasure that I introduce Christina Clark-Kazak, who is a professor in public and international affairs at the University of Ottawa and the project director of Unbordered Knowledge. She has a very modest biography. I could add that she is a former director of the Center for Refugee Studies, that is an author of, I think, at least 10 books as an editor and or author. And it is with great pleasure that we are able to participate in the launch of one of her more recent books, Age and Immigration Policy in Canada. Please join me in welcoming our friend Christine.
Okay. I'm sorry, Michelle, but I somehow have lost the PowerPoint.
One moment for technical adjustments.
Okay, hi everyone, and sorry for the technical difficulties. We're trying to do this hybrid, which introduces some additional challenges. I'm hoping that everyone can hear me online. Okay, so I'd like to thank Michelle Millard and Michaela Hinia for having organized today's event. And I also want to acknowledge that we've done the Indigenous affirmation, but I also want to underscore that because we're thinking about aging and migration, that many Indigenous peoples have a different perspective of aging. And when we think about the social construction of age, which I'm going to get into in a moment, it's important to recognize that there's different ways of knowing and doing in relation to aging. And so I also want to acknowledge traditional knowledge keepers, both young and old, when we're thinking about both immigration, recognizing that Canada is a settler state, but also thinking about the intersection of immigration and aging and what we think of in terms of aging. It's really fitting that this book launch is here at York University because, in fact, the genesis of this project started here when I was still a faculty member at Glendon College and affiliated with the Center for Refugee Studies. And I'm really pleased that Susan McGrath is here because Susan supported my work very early on, including through the Refugee Research Network, which sponsored a network on age and migration. And this is one of the many initiatives that came out of that. So thank you so much, Susan. And I have to say that SSHRC funded the book, and it also allowed it to be open access. So it is free to download online, and I'll share the link at the end. I just want to also acknowledge my positionality because, again, one of the main points of this book is to think about age as being socially constructed. And so how we think about aging, but also how we think about childhood, adulthood, and older age depends on where we're positioned in these multiple and intersecting power relations. So I, for example, grew up on a boat on the West Coast and sailing around the world. So that gave me a very different perspective of childhood, but also of young people, because as a person growing up on a boat, everyone on the boat had a role. And there wasn't a huge differentiation actually between the different age groups because everyone was responsible for things on board ship. And I think that also gave me this notion of, especially in my very early work, thinking about young people not as people who have agency. And I think a lot of times, especially in Canadian kind of constructions of youth, and we'll see this also in the Immigration Act, youth are often constructed as being problematic and or as not knowing things. And in fact, young people have a very sophisticated understanding of the world around them. So what I'm going to do today is to start off with the research puzzle that sort of is at the heart of the book. Then I'm going to focus in on some of the key findings from each chapter, but I'm going to focus especially on the chapter that looks at forced migration, because that's most relevant to people here at the Center for Refugee Studies. And then I'm going to talk a little bit about what some of the recommendations that come out of this work. So the research puzzle really is this, is that the Canadian Charter on Rights and Freedoms, which applies to anyone who is physically present in Canada, not just Canadian citizens, has a very strong equity clause in section 15(1). And one of the equity categories is age. So in Canada, we're not allowed to discriminate on the basis of chronological age. This is very well developed, both in domestic law, but also in policies, and including hiring policies and things like that. But actually, in Canadian immigration law and policy, there's a lot of very explicit discrimination on the basis of chronological age, and also on the basis of family status, and on what I call social age, which I'm going to get to in a minute. So what is this contradiction? So I'll give a very specific example. Many of you will be familiar with the comprehensive ranking system, or what's known as the point system. Does anyone here know what is the threshold for getting to, what are the ages in which you get 0 points? Anyone know?
Let's say over 50.
So it's below 50. Any other ideas? So it's 45. Yeah, once you hit 45, you get 0 points. You also get 0 points for being under the age of 18. You have to be 18 or above to get points. Now, this is a labor market assessment. And so we can talk a little bit more. And in fact, there's a whole chapter on the point system. But fundamentally, this is discrimination on the basis of chronological age. And it's normalized. Many people don't question it. And in fact, many people, when I present this work, say, well, we should have discrimination on the basis of age because older people are going to be a drain on the health system. But imagine if there were 0 points for being a woman, or 0 points for being Black, or 0 points for having a certain sexual orientation. There would be protest. So why are we not protesting when there's 0 points for being a certain age? So this is kind of the crux of what this book is about, is to think about why are there policies on this? So what is the policy? So I'm in a public policy school. I used to be a public servant. I'm interested in what is the policy rationale for this age discrimination? But second of all, why is it so normalized? Why is it accepted by everyday people, but also within policy circles? And I'm also interested in bordering and how age and family status actually function to include, but also to exclude people from certain categories of immigration. So I said that there's discrimination not only on chronological age, but also on social age. So social age is this notion that aging is socially constructed. And chronological age is also socially constructed. So in other words, in societies like Canada, which are ordered by chronometric time, we have decided that somehow 18 is the point at which people miraculously transform from a child into an adult. Yes, there is some psychological and medical literature that may support this idea that development is more or less achieved. A human development is more or less achieved at the age of 18, but there's nothing to say that it couldn't be 17 and a half or 19 or 20, and there's a lot of individual variation. So in other words, chronological age categories are used as a very clear-cut way to distinguish between different age categories. But in fact, other markers of difference are as important, if not more important, in terms of thinking about age and aging. So, for example, gender. In many contexts, women or young women will be considered to be an adult at, for example, once they have puberty or once they have given birth to a child, which might happen before the age of 18, for example. And there's also other religious traditions that are like rites of passage, things like Naljot or bar or bat mitzvah, which symbolize a transition into a faith, which is perceived to be people having the ability to be able to ascribe to that faith, right? And so the idea of social age is not to deny that there's a biological process of aging, but to say there is also a social construction of aging that happens at the same time. And so this is very much inspired by feminist and gender theory to think about, yes, there's biological differences, but there are also social constructions, and it's made meaningful in particular times and places. Social age also changes over time. So my childhood is different than my children's childhood and is also different than my parents' childhood. And so we need to think about social age as something that's variable across different generations. So I'm not suggesting, because again, I've had this critique, especially by people who are lawyers or legal professionals. There is a utility to having chronological age. So chronological age is codified in national and international law. It provides protection, particularly for children under the age of 18. So the Convention on the Rights of the Child is the most widely ratified human rights convention in the world. The only state that is not ratified is the United States. And chronological age also gives us a proxy for biological development, right? So knowing if someone is a day old or a year old or 10 years old or 50 years old or 100 years old gives us some indication of where they are in the life course. But it's not sufficient, and it's not sufficient for a number of different reasons. The first is that people may not necessarily know what their chronological age is, and this is particularly the case in immigration contexts where people may not have documents to prove it, or don't have, or that there's, so they've either lost the documents or they never had the documents. And so in some cases, this leads to what Kimberly Siebel calls bureaucratic birth dates. And again, the Refugee Research Network funded the workshop on which she presented this work many years ago now. So bureaucratic birth dates are a January 1 or a July 1 birth date that's given by UN agencies, including the UN Refugee Agency. And what is done is they approximate the birth year, and then they give a Jan 1 or July 1 date. And so many people will have two birthdays, or many people will have these so-called bureaucratic birth dates. The second limit to chronological age, which I've already alluded to, is that other markers are as important, if not more important, when people think about the social construction of aging. So physical characteristics like gray hair or wrinkles might indicate to people that people are at a certain age, even if in fact they may have a lower chronological age. And finally, the other problem with the chronometric notion of measuring age is that there's huge variations even within the same document. So I'm going to show you about IRPA, but in the context of Canada, it's exacerbated because we're a federal state. So you have differences of provinces across the country. So you see here how when someone is considered as a minor child is as young as 16 years old in Saskatchewan. Interestingly here, this is a hybrid definition of chronological and social age because they have to be unmarried and under 16 to be considered to be a minor child. And then you have it as high as 19 years old in the north and in other provinces. And so what this shows actually is, even as I mentioned earlier, even chronological age is socially constructed because there's variation actually across different provincial jurisdictions. And so in the book, I'm taking a life course approach so what I'm trying to say here is that chronometric age is not, and chronometric time is not inconsequential. It does actually have some kind of meaning, but it's made meaningful in particular times and places and in people's lives. And so we can't use simply chronological age. It has to be complemented with a focus on social age, which looks at the socially significant transitions and events in a person's life. And I'm interested in the book to think about how do these socially significant transition points like marriage, education, retirement, how do they map on to the migration processes? So the second concept in the book is this issue of discrimination. So you'll notice in the title, the subtitle is Toward an Equitable Approach. And this is, again, picking up on the equity phrase or a section within the charter. But the opposite of equity is discrimination. So what do I mean by discrimination? So there's two kinds of discrimination. One is direct discrimination, when people are treated differently in the same circumstance because of chronological or social age or family status. The second is indirect discrimination. So this is where people are treated the same, but it has a differential impact on them because of where they are in the life course. So an example of indirect discrimination would be detention, immigration detention. So immigration detention for the same amount of time would have differential impacts on people depending on the life course. There's a lot of evidence to show that detention has particularly detrimental impacts on children in various stages of physical, emotional, and mental development, but it also has a differential impact on older people. So there's a lot of studies to show that incarcerated people, so in the prison system, not necessarily in immigration detention, but in the prison system, there's accelerated aging that happens within incarcerated populations. So this is indirect discrimination because it's the same treatment to different age groups, but it has a differential impact on those age groups. And the final kind of underlying concept in this book is the idea of discretion. So there's a huge amount of discretion in Canadian immigration policy. First of all, because the sovereign state of Canada decides who can come in and out of the country. And in Canada, a lot of this decision is centralized. So even though technically immigration is a shared federal and provincial responsibility, it's the federal government who decides, and it's often cabinet who decides, especially with temporary public policies. So this introduces a huge amount of discretion. And in fact, the Canadian government, historically and even contemporarily, has always said that they have discretion. So this is the quote from Immigration Minister Ellen Fairclough in 1958. She says, quote, "In the sense that it is selective, Canada's immigration policy is discriminatory. But it must be borne in mind that the potential supply of prospective immigrants throughout the world is practically unlimited, whereas the intake of immigrants into Canada must be a gradual process geared to the absorptive capacity of the country," unquote. So I've bolded in that quote this idea that, in fact, there is discrimination, and discrimination is justified because Canada is the sovereign state. It has control over its borders and its citizenship. And so it's only going to allow people that are beneficial to Canada and for which there's absorptive capacity. You'll notice that this narrative has come up very recently in relation to temporary immigrants, including international students and temporary workers, because it keeps coming back to this idea that Canada can only absorb so many people. But the second thing about discretion, is that there are people who have to implement these laws and policies. And so, for example, with the Immigration and Refugee Act, or IRPA, you have both the act, so the legislation, but you also have the regulations, which is the interpretation of the act in policy. And so again, I'm in a policy school. I'm actually very interested in the way that public servants interpret these laws and policies. And this is where the social construction of aging and family status is very important, particularly in deciding cases of so-called like families of convenience, right? So it's the immigration officials who are deciding whether or not a family link is fraudulent or not. And so this is where the social construction of aging and what is appropriate or not comes into play a lot. So the methodology of the book is there's multiple parts to it. It's a mixed methods study. The first is a textual analysis of IRPA and its regulations. I must state from the very beginning, I'm not a lawyer, I'm not a legal scholar. This is not a legal analysis of the law. It's a textual analysis, because I'm interested in actually the way in which there's discursive, like talking about age and age categories within IRPA and the regulations. I also want to give a shout out to Joanna Reynolds, who may or may not be on the call, who helped me with this and helped to develop the methodology for doing the textual analysis from the very beginning. And then I also did semi-structured interviews with lawyers, former government officials, and migration-related civil society organizations. Some of these individuals did have lived experience of migration, but I did not interview newcomers themselves, because the focus really was on the policy and how the policy was being implemented. The lawyers in particular were very helpful for me to understand the application of the law. And again, this discretionary application of it. And then I chose 3 case studies, and these case studies emerged from both the textual analysis, but also the interviews, where people, when I asked them, what would you consider to be discriminatory on the basis of age? These came up time and time again. The first is the point system, which I've already alluded to. The second is migration detention, because as I mentioned earlier, this is a case of indirect discrimination, but also in some cases, direct positive discrimination, in the sense that children are technically not supposed to be detained. They are, though. So, we'll get into that in a minute. This is one of the chapters. And the third is refugee and humanitarian protection. So this is where children, for example, who make an asylum claim, have a separate process. And so this is an example of direct positive discrimination. So in fact, the state is recognizing that they need a separate process. But there's also some direct negative discrimination, in the sense that once an unaccompanied minor makes a refugee claim and is accepted, they're not actually allowed to then include in their permanent resident any family member outside of the country, because the government is worried that in fact there will be a fraudulent or sending kids in advance. And again, I'm going to unpack this a little bit in the last part. So I'm just conscious of the time. I don't want to talk too long. So what this shows, if I can give you the kind of conclusion first, is that age discrimination is deeply embedded in the Canadian immigration law and policy, and it's across immigration categories. So this is another thing that I tried to do in this book, is to think about the different family immigration, labor migration, and also refugee protection, to think about them, because often these are treated separately, and often certain policies like the comprehensive ranking system are justified because it's a labor migration policy. But in fact, you see that there's a current that undergirds it, which is this notion that there's a discrimination on the basis of age and family status. The second thing that I found through this textual analysis is that there were ageist stereotypes that really are throughout the law and policy. I already mentioned the stereotypes in relation to young people. There's also a lot of stereotypes in relation to older people in the law and policy. And these are not necessarily borne out by the empirical evidence. So there's a lot of colleagues across the country who have done great work, and it shows that in fact some of the ways in which the state is assuming that, for example, older people will be a burden on the health system is not actually borne out in the empirical evidence. And finally, these discriminatory bordering practices are normalized and rationalized. And this is where, again, I highlighted the former Minister Fairclough's quote, because they're normalized and rationalized because the idea is that we don't have enough people, we don't have enough space for all the people who want to come to Canada. And second of all, there's a kind of human capital element to it, especially when we're talking about skilled laborers, so skilled workers. So the idea here is that, in fact, it's okay to discriminate on the basis of age because we're looking for able-bodied workers who are going to be able to contribute to the state. So I'm not going to go into all of the different chapters. I'm going to skip ahead to the one on refugee protection. If you want to ask questions on any of the others, I have my notes here so that I can remember what I actually wrote. I'm going to go to the case study now on refugee protection. So one of the first things that really came out, especially in the interviews with people, was the idea that unaccompanied minors are an exception under the Safe Third Country Agreement, and they also have specific protections in the refugee determination process. So I think that it's important to acknowledge where there are good and promising practices. So this is a good and positive aspect. So there's positive discrimination on the basis of chronological age and family status. So this is the idea that children under the age of 18 who come to Canada without a parent or guardian are in a especially vulnerable position and therefore need to have special protections when they're making their claim through the asylum process, but also should be allowed to enter Canada to make the claim as the exception under the Safe Third Country Agreement. However, as I mentioned earlier, once they're actually accepted as protected persons, they cannot name family members on their permanent residence application. So this means that they're permanently separated from their family members. And the idea here is that the Canadian state is saying that they want to eliminate human trafficking, but they also are concerned that family members will send their children in advance, especially through the US, where otherwise the family would be sent back at the border because of the Safe Third Country Agreement. And then once the person makes the claim, they then bring everyone else in. However, I mean, these arguments do violate the right to family unity. So you've already acknowledged, the state has already acknowledged that an unaccompanied minor is vulnerable because of their age and their family status. And then to make it so that the condition of them having protection is a very long separation from family members is problematic. The other point that I want to make here is in relation to the number of people who are actually making asylum claims. So this is very small. But what we can see here is that the age group varies significantly. And so there are very few people who are over the age of, in the 45 to 59 category, there's only 12.12, but after the 60 plus category, it's very insignificant. So what we see here is that it's very difficult for older people to get to Canada to make an asylum claim. And so this is another finding from the book, is that there's often in the literature, there is a kind of focus on one category of generation. And what I tried to show, in fact, that there's age discrimination across the life course. And so we need to also be thinking about why is it that it's so difficult for older people to be able to come to Canada, and what this means in terms of the demographic and the family relationships that happen and the intergenerational family relationships within refugee families. The other thing that's very interesting when we think about refugee protection is in relation to refugee resettlement. So when a private sponsorship group wants to resettle people to Canada, the Canadian government allows, as a policy decision, so-called de facto family members. So these are people who are outside the nuclear family, because normally the nuclear family is the definition of family within the Immigration and Refugee Protection Act. So this is an exception to IRPA, but it's in policy, it's not in law. So that means that it's very easy to change. The government could decide tomorrow to no longer accept de facto family members. But what this also acknowledges is an expanded notion of thinking about families beyond the nuclear family. So they acknowledge here that there are people who can depend financially and socially on the principal applicant. The other thing about the refugee resettlement that's quite interesting, and again, is a positive thing, is that they recognize that larger families should be prioritized for refugee resettlement through the government-assisted refugee program. And this is because it's often more difficult to find places for the larger families. And so you can see this with the BVOR. So the Blended Visa Officer Referred Program is a mix between private sponsorship and government-assisted refugees. And what you can see here is because of this privileging of larger families, is you have a large number of people who are dependents or children and young people. And so we saw this, and I'm looking at Michaela because she's done this great longitudinal study of Syrian arrivals, for example, where it comes out also in that work. So on the one hand, we're prioritizing larger families. The question is to what degree are we providing settlement supports for those larger families? But the point is that, again, in terms of this bordering practice, there are 2 points here. The first is that the Canadian government, in some cases, does allow an expanded definition of the family. And so this is a positive thing, but it's discretionary. And it often is related to these very specific programs, including programs where Canadian citizens and permanent residents are sponsoring people, so they're effectively paying for the policy. And another thing that I looked at in the case study on refugee and humanitarian protection is temporary public policies for humanitarian admissions. And I'm really interested in this as a public policy scholar because this is very discretionary, and also because it comes from cabinet and or the prime minister. So it's a very centralized decision-making process. It's not debated in parliament. Sometimes parliamentarians, especially from opposition parties, will raise it in parliament, but there's no formal mechanism for making these decisions beyond the cabinet table. And so what you get is a huge variation in the numbers of admissions in terms of the cap, the first category here, or the second column, but also in terms of whether or not a family anchor or sponsor is required. So there's a huge discrepancy, for example, between Ukraine, where there was an unlimited number of people who were allowed, and for the Canadian-Ukraine Authorization for Emergency Travel, the specialized temporary visa, there was no need for a family anchor. Now, if people want to regularize their status and apply for PR, they do need a family sponsor, but they didn't need it to get to Canada. Whereas if you think about Gaza or Sudan, for example, these are very small numbers, especially in relation to the magnitude of the displacement in both of these places. But also in both cases, you need a family anchor or sponsor. So what this is doing is downloading the responsibility for the settlement services to the family member who is already here in Canada. The other thing that's also interesting is that for Gaza, it's still a temporary visa. So even though the family member is agreeing to sponsor their family members, they're still getting a very similar status to what the Ukrainians have, which is a temporary status, which we now know is problematic because it's very difficult to regularize that status and make it more permanent once they're here. So what this shows actually is that there's a huge variation in whether or not people need the family anchor, but also there's a variation in what constitutes family. And so what I found here in terms of conclusions and recommendations is that, first of all, chronological age, the reason why, and again, as a former public servant, chronological age is often used as a very clear-cut way to include and exclude. If you need to know whether someone is eligible for a service, chronological age is a very easy way to do so. However, what we see is that chronological age, even in the same document, even in the Immigration and Refugee Protection Act, there's a huge variation in who's considered to be a child, from as low as 14 all the way up to 22 for a dependent child. So this is, if the idea is to have some kind of clear-cut measurement, there is no clear-cut measurement. And so this shows that, in fact, it's not actually as neutral as is being implied. Second of all, there's an elasticity of the family definition. And so this is where, again, in terms of the bordering practices of the Canadian state, they're allowing an expanded definition of the family when that responsibility is downloaded to the family member who is already in Canada or to a private sponsorship group. When they're tightening up on the family definition, that's when they will have to take responsibility for the dependents who come. The third main conclusion is that even instances of direct positive discrimination, so for example, with the detention of minors, and also for unaccompanied minors having exceptions under the Safe Third Country Agreement, there are still negative implications of that positive discrimination. So in the case of detention, for example, it causes family separation in some cases. And in the cases of the unaccompanied minors, again, it means that they can never sponsor their family members until they become an adult. And then again, they would have to have the financial requirements and everything. And finally, I haven't really focused on this as much in the presentation, but I have quite a long discussion of it in the book, especially on the chapter where I talk about the family categories in IRPA, is that the default migrant is still an adult, and the default family is assumed to have one principal applicant and everyone else depending on that principal applicant. But the reality is that family relationships are interdependent. And so a child might be interpreting for their family members, and that helps the family members navigate this new environment. But that's not captured in this idea of the principal applicant being, the person who is the decision is being made on. And also older people, again, they might be, they either have a separate file if it's resettlement. It's not necessarily considered to be interdependent, even though an older person might be taking care of children and or working in family businesses or doing reproductive labor to allow both adults to go out and work. And so we're not really capturing that in this sort of individualistic notion. And also it's a very kind of neoliberal utilitarian notion of family. And because a lot of these immigration statuses, particularly with these temporary policies, rely on a family member sponsoring. It also creates huge inequities and power relations within that family relationship. And so there's a whole literature on the dependent spouse, which I don't go into because other people have already talked about it. But there's not so much attention to what kind of family dynamics does this create when a family member here in Canada is sponsoring someone to come. That person is often staying in the family home. And they have a lot of influence over what that person can and cannot do. And that person's immigration status is directly related to that person who has sponsored them. And so this is a situation that's actually ripe for exploitation. And I'm not suggesting that everyone is engaging in exploitation. I'm saying that the Canadian state is setting it up so that some people's immigration status is very much linked to others. And it's all couched in this notion of dependency instead of interdependence. So in terms of some recommendations, the first is that we need a more systematic social age analysis. So the Government of Canada has recently introduced this Gender-Based Analysis Plus, or GBA Plus, and the plus is supposed to include age. It's not very obvious from the title. It's supposed to include age. So this is a good first step, but in fact, the Canadian government doesn't necessarily have the tools to undertake a systematic social age analysis in the same way that they will with gender, for example. The second thing is that we need more data, especially on older people. There's a dearth of data on older people, and part of this is because once you're past 18, you're an adult. So often there's an aggregation of all people over 18 and above, which is obviously, a huge section of the population. In some cases, we have age disaggregated statistics by like 5-year intervals, but not always. And so this is particularly problematic when we're thinking about specific policy interventions for people at different at different stages of life in the adult sphere, but especially for older people. I I would also say that there needs to be not only a social age analysis, but also more age sensitivity. So one thing I noticed, first of all, is that, again, there's a lot of inbuilt age discrimination in the way that certain categories of people are talked about. But second of all, even within the policies, there's ageist language. So, for example, Immigration, Citizenship, and Refugees Canada often refers to older people as elderly. This is not accepted in the literature. So the fact that it's in all of our policies is hugely problematic. So people are not aware that this is an outdated term and that we don't use this anymore. And finally, I would say that age is an equity issue. Like, I think that there's a utilitarian argument for saying we're not taking into account the contributions people are making across the life course, but there's also a normative argument to say that this is actually not okay. Age is supposed to be protected by the Charter. We have many cases of very explicit discrimination on the basis of chronological age, social age, and family status, and there needs to be more advocacy to try to change this, just like there was advocacy around gender discrimination. So I will stop there. This is the QR code because it is open access. So if you want to download it, that's the direct link. The link at the bottom is the link to the UBC Press page, and there is a green button that you push for the open access edition, so you can download it there. So I will stop there.
Thank you very much. In 15